And here we go. Thank you, everyone, for joining us. This is John DiMartino, President of Liberty Benefit Advisors. And here with me today are Giovanni Mancini, President of Treadstone Risk Management, and Ari Snyder, Partner at Busch Law Group. Hi, gentlemen.
Hey, how are you, John?
How are you? Good morning.
Good morning. Thank you so much for being on. Would you mind, Geo first and then Ari, giving the audience a little background on who you are, what you do, and what your roles are as it relates to working with public entities in New Jersey?
Sure. Giovanni Mancini, President of Treadstone Risk Management. This is about my 10th year now in the insurance industry, specifically to the New Jersey public sector. We represent about 27 or so New Jersey school districts, municipalities, and utility authorities. And for the most part, I've been doing both property and casualty employee benefits now for the large majority of my career, specifically inside that New Jersey public sector. And right now, over the last couple of weeks or so, we've had a keen eye on what was going on inside the New Jersey legislature in regards to the Chapter 78 relief bill. And this part and my presence here is to give a little bit of insight or some light that we can shed on what are some of the intricacies that some of the boards can be looking for as this legislature piece moves forward and as they go in and out of negotiations.
Excellent. Ari?
All right. And as John mentioned, my name is Ari Snyder. I'm a partner with the Busch Law Group. We're a law firm located in Metuchen, opened in August of 2014. Currently, we represent over 50 school boards across the state. For me, I do all of the labor work for our firm, the personnel stuff, and I do the far majority of the negotiations. Currently, I'm negotiating contracts for roughly 14 clients.
Excellent.
Excellent. And I think that's going to be a big part of what we want to talk about today is how this bill could potentially affect negotiations. But before we jump in, big disclaimer here. Even though Ari is an attorney, nothing that we say on this podcast is to be misconstrued as legal advice. This is simply informational to help you have the appropriate conversation with your stakeholders, whether it's a business administrator, board, your board attorney. That's really what this conversation is about today. Of course, also keep in mind that we don't have all of the details on this law yet. So, for example, we don't have rates for the new educators health plan. There's a lot of other unknowns as well. And we'll start off talking about a brief overview of what the bill is and what we know about it. We'll talk about some questions that we still have. And then we'll really dive into the negotiations aspect of this bill. So just a quick start. Geo, do you want to give us just a very high-level overview of kind of how this bill affects public entities, specifically school districts, and pretty much anybody who participates or could participate in the SEHBP? That's really who's affected by this bill, if we're just painting with a broad stroke.
Sure, of course. I think it was about a week ago we sat down and did a similar podcast. I think it was March 19th. So the Educators Health Benefit Fairness Act, aka the Chapter 78 relief bill, it's made its way through the state legislature, passing in short order. And it's going to apply to school districts, regional school districts, county vocationals, special ed, school districts, jointure commissions, pretty much everybody, educational services commissions, anything state-owned, operated, charter schools, county colleges, and the like, which are established and pursuant to Title 18A. So we're talking about everybody here that could be applying to or participating in the SEHBP. The changes are going to be effective on July 1st, 2020. So what we're talking about here is really only a few months away, and it's something that not everyone is essentially educated enough upon to make an informed opinion. So what we're trying to do here is provide a little bit of insight for that. What's really going to be happening in the shakeup is we're going to be taking the SEHBP from an 11-plan offering down to a 3-plan offering. The majority of members had been in either the Direct 10 or Direct 15 inside the SEHBP, so those two are going to remain. But there is going to be the introduction of a new plan. And that plan, the Educators Health Plan, is going to be something that closely mirrors a little bit of what we used to see and what will be known as the Direct Zero, what was known as Direct Zero. The Educators Health Plan is going to be similar to that in the way that they operate as far as prescription and out-of-network reimbursement. And then we're going to kind of kick in a little bit about some of the summaries of the benefits, and then how they might affect people in Direct Zero was. So if you want to shed some light on that.
Sure. And I think when we're talking about this new bill, the first thing it does is obviously the addition of that new health plan, the Educators Health Plan, which to your point is very similar to the Direct Zero. From a financial position, what this new Educators Health Plan is supposed to do is hit a price point that is significantly lower than the Direct 10. So right now, the Direct Zero is about 18% lower than Direct 10 when it comes to premium contributions. We anticipate, because the Educators Health Plan is a slightly watered down version of the Direct Zero program, that maybe that'll be closer to 20 to 22% discount versus the Direct 10. So obviously, if you're just contributing on a Chapter 78 schedule, both the employee and the employer cut their contributions by 20%, right? If nothing changes. One of the things that they did, and why they call it the Health Benefit Fairness Act, is because what they're essentially doing is anyone who enrolls in the Educators Health Plan, they're tying it to a percentage of salary, which is anybody who's been in any collective bargaining situation over the last 5 or 6 years knows is what all the locals have wanted. Now, with that said, they didn't want to give up Direct 10. They just wanted to move to a percentage of salary. So this plan allows them to buy down and then enroll in the Educators Health Plan, where they're now contributing based on the percentage of salary. Because of that, what we see is the employees' contributions decreasing not just 22%, but anywhere on average from 30 to 50%, depending on what salary band they're in. So very substantial savings for the employee. And of course, the employer, because the employee is saving more than that 20%, so they're not exactly splitting it 50-50. We're seeing that employers are saving anywhere between 10 and 20%, based on the salary tier. So there is, a pretty big impact for buying down. And I think that the spirit of the bill is really hoping that percentage of salary contribution is enough to get people to move. Because I guess, Ari, kicking it to you real quick, we haven't seen any movement in any health plans. 85%, maybe more, are still enrolled in Direct 10 or Direct 15 or whatever the base plan is. In some of the negotiations, have you seen any real incentives work so far to get people to buy down?
No, it's been very difficult, no matter what the incentive, no matter what the district, to get enough of the employees or members of the union to buy down in order to get a real savings to the district. I can't really think of any examples offhand, and that's the single biggest question I have with this new bill, is the incentivization to be able to contribute a small percentage of your salary enough to get a majority of the union off of the Direct 10 or the Direct 15 to go to that plan. I think the evidence so far, at least from the districts I work with, would say no. Hopefully I'm wrong, because if I'm wrong, there'll be a lot of savings. If I'm not wrong, I'm not sure how much better off these districts are going to be financially.
No, and I'd have to say we totally agree. I think a lot of this change is exacerbated by the fact that we're in the middle of the COVID-19 pandemic. Most of us are quarantined. We're not able to go to work. Most of the teachers are teaching remotely. A handful of the business office is in just so they can make payroll and make sure everyone's still getting paid. But there's a few things that complicate this, particularly as it relates to opportunities for July 1st, 2020, as well as negotiations that, for bargaining units that may have their contract end on 6/30/2020. So the first thing is, like we said, these changes are effective pretty much immediately. So 7/1/2020, these changes are supposed to be in place. There's a little caveat that they can push it to 8/1. We'll see what happens. But if it's 7/1/2020, all, like Geo said, 11 plans that were offered in the state plan are going to be whittled down to 3: Direct 10, Direct 15, and the Educators Health Plan. So there's not even going to be a Direct Zero anymore. So that's item of interest number one. Number two is that there is a special open enrollment period that should be slated somewhere between now and July 1st for employees to go ahead and make changes if they want to buy into the Educators Health Plan. Now, one of the things that we've seen taking it back when the Direct Zero rolled out is, and Geo, you and I worked on a bunch of these together, was that where we were participants in the open enrollment process at a district, where we sat down with employees, educated them on what the Direct Zero was, how it worked, and which types of employees may benefit the most from it and which ones may not like it. We had some pretty good enrollment. Maybe anywhere from 15 to 25% of the population would trickle into the Direct Zero. Not because we were trying to fit a square peg in a round hole, but because it was truly in that employee's best interest to enroll in that program. So one of the things that we also noticed is when we weren't there, they had virtually no enrollment because there was no one really to educate the employees on the changes that were taking place. And don't get me wrong, the state plan does provide some educational materials, But in large part, what we find is that no one uses them. And I think that is potentially what's going to happen with this special enrollment period, where there's not going to be enough communication. There's not going to be enough action. I mean, we're technically not even allowed to speak, to sit down next to some of our employers right now, or organizations we represent. So it's going to be very difficult to educate them appropriately on this bill and how it works. I mean, what are your thoughts on that scenario?
Yeah, so I actually have a question. This is really going to get sent over to Ari in a second. One of the pieces that I've been kind of concerned about, mainly because we don't have the information on it, is there's a small caveat inside of the educator's health plan where they go on to talk about, and what we really talk about, the three differences between the Direct 10 and the Direct 0, and now the educator's health plan, where the out-of-network reimbursements, the prescription changes, and then subtle changes to the caps essentially on what they pay for chiropractors, acupuncturists, and physical therapy. There's a line in there that says, for the educator's health plan, it's subject to the out-of-network limits as for the state health benefits plan to take effect as April 1, 2020, or as soon thereafter as reasonably practicable. So Ari, my question is if this change to the SEHBP, let's say that they're going to cap chiropractors or acupuncture effective April 1 inside the SEHBP, and you're a district that's going into negotiations or is in it now, and currently your plan pays something that's more generous than that. If these changes were to be taking effect on April 1, and you're looking at a July 1st change into the SEHBP, how does that affect what you're thinking about or what you're talking about inside of negotiations?
Well, that's definitely a loaded question because it goes beyond that single point. But obviously, if this law is going to take effect come July 1, several months after this April issue that you're addressing, it will really be incumbent upon the NJA or the local union representative to educate their membership, who's going to ultimately vote to ratify the contract that's being negotiated right now, as to how that change will impact them, impact their benefits moving forward. Because once this bill ultimately passes and becomes law, obviously whatever it says is going to be the letter of the law, regardless of what the collectively bargained agreement says, or regardless of what benefits the employee base is getting at that time. Obviously, current contracts that are expiring in June, the new benefit that will be negotiated, the new benefit that will be required through this new bill will take effect for the new contract only and won't impact them prior to that date. Not sure if that answers your question, but I think there's a lot of things that are going to ultimately be changed, that it's going to be incumbent more so on the NJA or, like I said, the local representative to make sure their unit base is educated on it.
That makes sense to me. Now, I guess the other part, one that we do want to make mention of it, I think it's the goal of, and this is my opinion, of course, I think the goal is to ultimately move people to this educator's health plan. So what we don't have right now is the rates to the Direct 10 and Direct 15, or if they're going to make any changes to those rates or keep them where they are and just introduce a new rate for the educator's health plan come July 1st. I guess they have the ability to maintain the current rates for the Direct 10 and Direct 15. However, if there's not enough migration, and even with perfect information to the employees, they're still in a state of flux right now due to what we have going on with the coronavirus pandemic. And what I anticipate happening is we're not going to have an enormous amount of movement over there. I think what will save them here is that everyone still has to enroll in a plan here, physically enroll in a plan. So there will have to be a conscious decision made by each employee, which will allow them the opportunity to at least consider and contemplate potentially moving into that plan. But while you have something like this going on, it's usually most people are not going to go to something with less benefits during a situation like this. So if I anticipate correctly that everyone's kind of going to remain a bit in the status quo, what I do anticipate next year is that we might see some heavy rate increases to the Direct 10 and Direct 15 with the purpose of them moving most people to the educator's health plan, and then the other plan that's going to be rolled out, the New Jersey only or the New Jersey network of the Garden State plan that they're going to be offering. I guess really what my question is when districts are going into negotiations now, should they be looking at a longer term as far as years, or should they be looking at maybe a 1-year plan? And what would you kind of recommend to someone in that state of flux or right into negotiation?
So all of the districts that I'm currently negotiating with maybe the exception of one or two who are very financially sound districts, have been waiting on this bill. And as you guys know, there was an assumption maybe even a month ago that a totally different bill was going to be passed and there was going to be a bigger opportunity for savings for the district. My position has been most recently that a one-year deal may make sense because we don't know if there's going to be a rate increase in year 2 for the Direct 10 and Direct 15. We don't know how many employees will switch into the educators plan right off the bat come July 1, 2020. So it's impossible for a district that has financial concerns right now to plan 3 years out, 5 years out, when they don't know, for example, if they're going to settle at a 3% or a 2.5%. How is that going to be impacted in light of the cost of healthcare? It's a total unknown. I know there was an assumption or a push by the NJA that, oh, this new deal is going to save districts a ton of money. That's what Sweeney said. This is going to save districts a ton of money. But like you said, without knowing, and this was my first question to you guys, without knowing how much the Direct 10 or how much the premiums are going to be for the Direct 10, Direct 15, if they're going to be the same as they are right now, it's impossible to tell a district how much it would cost them with the assumption that, 95% of your employees are going to remain in those two plans. If it's the same cost, they'll know, obviously, but they're not saving any money unless they hire enough new employees who are forced into that educator's plan to save money on the premiums. And again, the districts in bad financial shape right now are not the districts who are able to hire a bunch of new employees and get any savings from that end.
Exactly, I agree.
And one of the things, some of the complicating factors as it surrounds negotiations, right? So if you're in the state plan and right now your base plan is the 2030 or the 2035 or anything other than Direct 10 or Direct 15, that plan isn't going to exist anymore. I mean, what types of conversations should business administrators and boards be having with their board attorney about how they dance around that? I mean, do they just go back to Direct 10 and Direct 15?
And incur the cost? What do they do?
Well, I think for a district that's in a contract that's not expiring prior to the effective date of this bill, they'd have few options, unfortunately, because as I said earlier, whatever the law says controls over what the contract says. So as I read this bill, and you guys could correct me if I'm wrong, they would be required to roll out the Direct 10 and Direct 15 and the educators plan, and they have to get rid of that 2030 plan, assuming they're in the state health benefits program right now. In that event, they're going to lose money on this deal because I think it's fair to assume that the majority of that employee base in the 2030 will probably go into the 10 or 15.
I agree.
Or perhaps it's possible that they'll like the savings that they receive from going in that 2030 and the lower contributions. And we'll say, you know what, the educator plan makes more sense. It's more similar to what I had. But really their options at that point, other than taking extra care to make sure that their employee base is educated on the benefits of the educator plan, the similarities to their 2030 perhaps, they can't just unilaterally reopen the contract and hope that the association will agree to do that. Doesn't work that way.
Right. Yeah, I have major concerns about the reason why, if you look at the 2030 versus what the Direct Zero was before and why somebody would make a conscious decision to go into 2030 versus the other one, most of it surrounded the three pieces that this changes, that at a network reimbursement being lower in Direct 10, the mandatory generics being something that people are a bit scared of, whether they realize that they're on generics almost entirely now, or that that the generic wouldn't be a problem for them. It scares them a bit, especially with groups with family members and that have been taking a specific maintenance medication that is not a generic. And then that acupuncture and chiropractic piece, New Jersey Education Association teachers use chiropractor and acupuncture more than most groups in this country. So those three pieces are what scared anybody that didn't go to the Direct Zero back then. Mostly were scared because of that, and they went to the 2030 as they were similar types of price plans. So I guess some of my concern here is if we're talking about the out-of-network reimbursement and the out-of-network benefits, they're much closely mirrored in the Direct 10 and Direct 15 as opposed to the new educators health plan. To get people to move there when they didn't make the conscious decision prior because of some of those fears, I think is going to be a stretch if we're lucky. And I think many of them are going to say, you know what, I'm going to go elsewhere. And in that circumstance, is it such that the district is just going to bore the cost of it to whatever the contribution sharing is going to be? Or is there a way for them to say, this is what your benefits were on this date? It really, I guess, depends on what the CBA said, what your benefits were on this date. The upcharge is going to be borne by the district regardless, or is it basically them just kind of saying to you, you're going to be able to pick and choose, and the district is just going to kind of lose here on this one.
Well, if the parties had the foresight to include certain language in the contract to protect the board, then that would be the route they'd go, and perhaps the board wouldn't be hurt as bad. I would imagine the far majority of contracts where this is going to be an issue don't have that language, and the cost is going to be borne by the board, and the result of that is that more likely than not, the board, in order to save some money, will have to lay off staff. So it ultimately affects everybody.
This is a tight time crunch we're talking about, right? We're going to be talking about this over the next couple of weeks. People are going to take a look at their CBA and they're going to say, okay, I'm one of the ones that have a problem.
Absolutely. And to your point with, or one of your points about the fact that we're all home right now because of the COVID-19, it's actually much more difficult to be able to educate, get one of you guys to come into the building, for example, and talk to the union about the benefits of the educators plan, how that's similar to the 2030 perhaps, which makes it even more difficult or less likely to assume that we're going to get enough people to switch or to choose that educators plan as opposed to the known plan, the direct 10 or the direct 15.
Okay, makes sense.
All right, and the districts that you're speaking with that are either in negotiations or ending negotiations soon, I mean, has there been any conversation with them about either jumping into the state plan to take advantage of the law or jumping out of the state plan in order to maintain their current level of benefits? You know, for example, if someone had the 2030, I mean, are people even considering that right now, or is this still so new that's not even really on their radar yet?
I've had that question in one or two districts, or brought that point up in one or two districts. With regard to going from state to private, I've always been told it's just too expensive. It wouldn't make sense for the district. Okay. I haven't had any districts yet that have considered going into the state health benefits plan or program, I should say. And the problem now is going to be a lot of contracts, require, in order to make a switch from one plan to another, benefits must be equal to or better, right? And now with the limitations with the new bill for the state plan, it would be difficult to leave a private plan where you're offering several plans. And from what I understand with the bill, you can still offer those plans if you're not currently in the state health benefits program, obviously. Right. So you're likely going to get an unfair practice charge alleging that you made the switch to the health plan or the state plan, and now our benefit options are certainly not equal to or better. So it doesn't seem that practical, although if it was able to be done, I think it might be beneficial to certain districts.
Definitely. And that's some of the feedback we've been getting from some of the unions that we work with is, they believe if the out-of-network benefits are changed for the direct 10 and direct 15, in most equal to or better than letters, out-of-network charges are not technically considered part of equal to or better than, but there's still a lot of pushback when we've changed that type of thing in the past. The other thing that was brought up is right now there's 2 RX options in general for every health plan in the state plan. Option 1 is just a copay, so you pay $5, $10, whatever it may be. The other is a coinsurance model, where you may pay 20% or 10% coinsurance, right? So you just pay a percentage of what the cost is. From what it looks like, and the rumblings that we're hearing is that coinsurance option is going to be removed, and that's the less expensive of the 2 options. So particularly from some of the Bergen County districts, it seems like almost all of them are on the coinsurance model instead of the copay model. So it'll be interesting to see whether or not you can make the jump either way because they're taking that benefit away and how that will look moving forward if, that option's eliminated. Right. If you're in a private plan, I would imagine that the union would push back and say it's not equal to or better than. We like the coinsurance option. That's what we agreed to. So if you go back, we're going to kick and scream. And I think there's some ground to stand on there. But on the flip side, if you're in the state plan, it looks like you just have to kind of take it as is and move along, right? I mean, and take the increase in the rate action.
I agree.
Now there's some other complicating scenarios that we're thinking about. So one of the things that Gio and I are pretty proud of is we negotiated one of the first contracts back to 1.5% of salary, and the base plan became the 2035 plan. So if that district was in the state plan, I mean, what do you do? I mean, it doesn't look like anything in the law says you can unilaterally change the amount that employees are contributing now that they have access to the direct 10 and direct 15. And with that plan being eliminated, I mean, does the board have the right or ability to say, okay, well, the base plan used to be the 2035 plan, but since that doesn't exist anymore, the new base plan is going to be what is it going to be? The educator's health plan for everybody? I mean, I don't really know what somebody would do in that scenario. I mean, what types of things should both the board and the BA consider in that type of arrangement?
And that's something we touched upon a little bit, but I think the most logical thing to do at that point in time, and hopefully it's a district that works well and gets along with its union, is simply explain that the financial impact, now we've lost the benefit financially that we gained from getting you guys to switch to that 2035 plan, right? Now that we're losing that because of what this state bill is going to require, rather than have to lay off staff and go that route, work with us. Let's negotiate a base plan. Let's negotiate the base plan to the educator's plan, which is most similar to that 2035, and not have your entirety of your staff or the majority of your staff go into the 10, 15 and financially kill us. But you know what? Other than that, the district's in a very bad spot. I wish I could give you a better answer or a better outlook, but that's a concern that, in every negotiation meeting I've had in the last 2-3 weeks, and I will have in the next couple of weeks, that's going to be one of the major concerns.
Right.
Yeah. So there's a point that I'm also more concerned about as we get into this a little bit, and as we, as brokers on our side, and ultimately, as counsel for the board, we do make recommendations, and we have to be considerate of the financial obligations or concerns that we have about some of the funds that we're talking about. And, as we, peruse around the industry and the marketplace, we have to look at, kind of the financial health of where we're making a recommendation for somewhere to go. And it's been, John and I, over the last few years, we've noted that the SEHBP has, in my opinion, some financial concern as far as the total amount of reserves that they have to pay claims. And I just want to talk a little bit about some numbers real quick. We have some other funds that have some financial history that they've shared with us. And in any given year, the influenza costs are roughly about 1% of whatever the kind of the surplus held. That's kind of what you figure out you're going to spend. About 1% of the total amount of money that's taken in is going to get spent out on influenza costs. And some of the modeling that we're seeing right now is that the coronavirus, COVID-19, is going to cost somewhere between 10 times or so higher than influenza. So, if we're talking about something being about 1% of something to now being about 10% of the total surplus that we took in, when we're sending some of our districts there, it's something that we should be considering as far as they're getting, if the state plan is going to be getting hit with, a 10% budget buster, essentially, that they were not expecting for, how is this ultimately going to affect our recommendations that we make for districts to potentially go in there? And should we be looking at, potentially the financial health? I know that on the property and casualty side, if I send in a district to a joint insurance fund or to insurance carrier that is, relatively financially unstable and goes insolvent, that's eventually going to come back on me and be a poor reflection of my ability to recommend. So it's something that I want to just kind of bring out and mention that it's about a 10% number what we're looking at now as far as costs over what they would have assumed for a normal influenza season. So, something, again, when we make a recommendation potentially to go to the state plan, that's a big concern on my plate right now for some of our clients.
And is that concern that in year 2 of this bill, in year 3, the premium prices skyrocket as a result of that?
I think it might happen across the board, but I'm more concerned about it being in the state plan because I think that the last 2 renewals that they've had, I just can't look at the numbers and say they make sense to me for how they were derived. I think a lot of it was, and it's not just the SEHBP that would do this. Other insurance carriers in years have enticed members to come in with lower renewals, as a way to build up some of their that larger scale to then, hopefully be able to level out a bit. And I have major concern about it at the SEHBP level because the last 2 renewals have been disproportionately low to the amount of surplus that they have and the amount of claims that they've been paying out. So this, kind of an unexpected, potentially 10% bill that's just falling at their feet is something I have major concerns about.
That's a very good point, and that's a discussion point I've had with all of my clients. The concern is, I always link, and I would assume most boards do this, salary and health benefits get linked together, right? So a district that's looking to settle a 3-year contract or a 5-year contract can say, if everything was going to be stable and they were confident that the premiums were going to remain the same, and say we can afford a 3% over 3 years or 5 years. Right now, it's hard for me to recommend that. It's almost impossible for a BA particularly in districts not well off financially, to say, yeah, we could do that over the course of 3 years, not knowing what the premium increases are going to be. And particularly, like you're saying, assuming that there might be a big jump in premiums. That
Right.
circles back to the conversation we had earlier about, a 1-year deal right now to see what the premium. So when although nobody wants to go back to the table in 6 months, the idea of being able to go back to the table and evaluate where the premiums are going to be for 2021, 2022, makes it more possible, more tenable for a board to come up with a reasonable salary settlement over the course of an extended period of time. Otherwise, you're kind of guessing. And in my opinion, and I think many VAs' opinions, that can certainly lead to an issue in year 2 and 3, an issue with the ability to pay your employees, and the possibility of having to lay staff members off because you couldn't project out.
Yeah, I agree. Right. Yeah. Go ahead, John.
I was going to say, all right, one of the other things that is interesting about the law is it does change kind of the landscape of collective bargaining as it relates to benefits with a few different provisions. So the first one is you're no longer allowed, let's say you're out of the state plan, because you only have 3 options there. If you're out of the state plan, you can no longer offer a program that is going to have a premium that is higher than the educator's health plan, right? So that's issue number 1. How do you think that will complicate things? Or, has there been some creativity in the districts that you've worked with, or what you've been hearing about districts who have said, you know what, let's make the 2030 the base plan for a new hire, or let's get creative and make it the direct 15 or single coverage only? I mean, how do you think the inability to have some flexibility with plan design and offering unique plans, which is one of the big reasons why school districts move to a private plan, is because they have a little bit more flexibility and control. I mean, how do you think that's going to impact negotiations? And do you think it's going to be a good thing or a bad thing long term?
Twofold. Number one, just to be clear, we're talking about districts outside of the state plan, correct?
Correct.
Yep. All right. And I have some districts that are in that 2030 plan. And they obviously, I also have some districts that use the difference card to get there. And as I understand the bill, just to be clear, plans that are currently in effect can remain. So example, the districts that have that direct 2030, the direct 15, the direct 10 in the private plan are going to be able to keep those plans. They're going to have to offer the educator's plan though. So yes, it is going to be a little different. I don't necessarily think it's going to be problematic, but it's going to take away the creativity. And I know you guys mentioned you guys negotiated a 2030 plan with a 1.5% contribution rate. I don't know, was that in a state plan or a private plan?
Yeah, it was about 4 years now. It was about 4 years ago now that we did it. They actually, I think, renewed that CBA kind of as is. It ended up being beneficial for both. I will say though, when they did do that, the state plan being the state plan, they made fairly major changes to the 2035 the next year, where they introduced a larger coinsurance inside of the in-network piece. But that is the way of the state plan. They kind of can unilaterally do whatever they want there in that regard. So they did know that going into it. But I think it was beneficial on both sides, mainly because, and we talk about this all the time, when you make a change from the direct 10 to the 2035 or a lower plan, you're essentially liquidating your compensation package on that side in order to shift that money over to salaries, because that's really what their ultimate goal was, to pay more. They were one of the lower paying districts in the county, and they were trying to kind of jump up on that ladder. So that is, a big issue. There is, and this is for kind of our BAs, there was a few questions that I know that NJ Asbo had asked and had published about, some of the questions that they had going about this. And I do want to answer some of those for them in case we can help any of them. One of them had to do with, it says that until July 1st, 2027, employees that are enrolled in the educator's health plan will have the ability to select, those plans. But whatever is in place that for that plan year, the level of benefits and the contributions are not going to be modified. So because of that, we have some concerns that, the districts are going to bore a large percentage of these costs. And I think it kind of plays into the idea that the 1 year is probably the best to go with right now as far as total term, is that if it's going till 2027 and we're not changing the contribution structure, at least on the educator's health plan, what happens if the savings don't materialize? What does the district do if these savings haven't materialized? The premiums, kind of jump up here, and then these could really escalate quite quickly for a business administrator looking at their budget that, over year 3, 4, and 5, I'm no longer in a position to stay solvent. So I think that kind of plays into our recommendation to, kind of keep those term limits as tight as you can, at least in the beginning, to see how this plays out.
I agree with that, and that's a point we were speaking about a little while ago. I mean, the unknown is an issue here. You're better off negotiating a short contract, being able to negotiate a succeeding contract where you recognize and the association recognizes from day one that you only have, you can't give them a raise, or you can only give them a very small raise, as opposed to getting stuck with a large raise or even a moderate raise for 3 years or 5 years, where you have no options at that point. You can't just unilaterally reopen a contract. Your only option, it's not a good option for anyone, is to lay off staff to save money.
Mm-hmm. So I have one question. I don't know if we came up with an answer yet to this one, John, and maybe Ari, if you have any idea, or we can just we'll table it for another time as we get more information. It says in the bill, newly hired NJEA employees.
Right.
The question that came in from one of our business administrators was in regards to the Janus Act and opting out of the union. So the question was, teachers can opt out of the NJEA if we hire someone after 7/1/2020 and they choose to not be an NJEA member. Do they still have the option, or are they still, required to have all of those plans? I think, in my opinion, if you're in the SEHBP, you're kind of stuck with, whatever you were able to offer. The question was in regards to, the Janus Act, and if they opt out of the bargaining unit, I still believe that whatever is collectively bargained is what's going to be offered to those, even if they have opted out. Right. Is that correct?
That's correct. That's my understanding as well. And my position, not having given this much thought until right now, would be that they would be bound by those 3 plan options in the state health benefit plan.
Okay, makes sense to me.
Now, Gio, one of the complicating factors there is any new hire hired on or after 7/1/2020, or any new NJEA members, more specifically,
right,
does not have the option to buy up to Direct 10 and Direct 15. The only plan that they'll be allowed to enroll in is the Educator's Health Plan. So I guess one of the other questions is, okay, so if somebody is if I'm a new teacher, just graduated, got my first job, maybe I've been a sub for a while, and now I'm officially hired by a school district to teach first grade.
Right.
On day one, I'm offered benefits because I was hired on, let's say, 9/1.
Okay.
So if I'm in the NJEA, does that mean that I have to be in the Educator's Health Plan? And if I decide, similar to the Janus Act, to opt out and be a non-union employee, does that mean that I get thrown in with the non-unions and can potentially buy up to Direct 10 or Direct 15?
Yeah, that's the interesting question. And if that is the case, and let's say you were a brand new teacher with a family and you had, some extenuating medical circumstances that enticed you to get into that Direct 10 or Direct 15, you would probably push pretty hard for that, I'm assuming, right?
I have to agree with that. It's just so unclear what the definition of a new hire related to the NJEA is.
And regardless of NJEA status as a member or not, right? And I would think that when they wrote this, that was probably their intention, but because they haven't really spoke about it, or at least it's not in the language, we have to now make a guess, basically, as a result of it. And that was one of the questions that came in, is what do we do with those new hires?
Right. No, totally agree. So as it relates to the cost containment activities, one of the things, and I don't know how the stat is going to be used, but one of the new additions to this law is there's additional reporting requirements. So now at the end of every fiscal year, the business administrator and their team is going to have to put together a financial statement tracking all of the plans that everyone's enrolled in, along with the cost and the coverage tiers. So from that way, they can track both the employees' contributions and the board's contributions to the healthcare. I'm not 100% positive that, particularly for some of these groups who may have negative financial consequences, that their reporting is going to reflect favorably. Wild speculation here. How do you think that's going to be used? And if this snowballs into an issue because some districts have negotiated lower base plans that are now evaporated from the state plan, do you see a scenario where maybe we turn course or change a little bit? And I bring this up only because the first draft of the bill, before the updated one that Sweeney agreed to, basically said that they were going to look at the health plans every year and then make changes as they saw fit to keep the cost in line with what's needed in order to have savings for both the school districts and for the employees. But it appears as though that provision's gone.
Mm-hmm.
John, if I could just, I don't mean to interrupt your flow there.
I do agree with that.
Go ahead, Gio. I'm sorry.
No, it's all you. You're all set. Go ahead.
I was just going to say, I pulled up the copy of the bill in front of me, just to go back to your last point, not to, I don't mean to interrupt you, but the way I'm reading this, an employee commencing employment on or after July 1st, but before July 1st, 2027, who does not waive coverage shall be enrolled by the program with the employee's dependents, if any, in the New Jersey Educators Health Plan. So the way I'm reading that is, any employee, regardless of whether or not you choose to opt out of the union.
Okay. Oh, wow. That's fairly sweeping. So the other question is, how do you define a new hire? So one of the things that ASBO was taking a look at is a new hire somebody who's new to the district or somebody who's hired maybe into the pension system for the first time? Is there anything around that part of the bill that you just read that would maybe dive a little bit deeper into that?
Yeah, and that was a question I had as well. As I read the bill, it refers to any employee commencing employment, which to me means regardless of whether or not you were employed in another district for 10 years, or if you're a brand new teacher. I suspect that some further guidance or regulations might come out concerning that point, but the way I read this on its face would be any new hire to the district, regardless of years of experience and previous plan option abilities.
Wow, that's pretty substantial. So that could significantly curtail movement from district to district, particularly for some of those legacy employees who have been there for 5, 10, 15 years, who haven't given up their Direct 10 plan yet and show no signs of giving it up. It seems as though that would be a very good reason to stay with the district that you're currently employed at, which could have some negative consequences as well. I also think about it on the business administrator side as well. Similar to the impact that the superintendent's cap had, are BAs going to stay put because they have a better health insurance program? Or are they looking to, if they swap districts, it stands to reason that they would be enrolled in the educator's health plan as well, right?
That's the way. And again, a lot of this is an unknown and
right.
Best guess, but that's the way I'm reading this.
Interesting. Okay.
Yeah. So there's an interesting piece that I know got brought up, and we're probably not going to have as much of an opinion on it, mainly because, we don't really handle as much with budgets. But there's a part of the law, Ari, if you're taking a look at it now, it goes into that ties in the savings. So the bill requires actual savings realized by a school district as a result of the implementation of the bill to be used solely and exclusively by the school district for the purpose of reducing the amount that is required to be raised by local property tax levy. So there's going to be an onerous amount of reporting that we previously touched on that a district is going to have to do now in order to be able to show the amount. And we'll talk about a little bit about exactly what type of reporting they have to do, but the amount of money that they saved. And now that's going to be tied into the calculations for the tax levy. So one of the questions that came from ASBO says, tying the tax levy adjustments will further, hamper the districts whose costs cannot be covered by the 2% tax levy. So there'll be districts that are often using savings from health insurance to cover salaries, technology, safety, security. And in this instance, now we're going to have a tax levy calculation that's going to be essentially calculated with part of the savings that they're using. So some of the concerns on the plate of the BA is, how am I going to be sure that the tracking that I'm doing is, perfect in order for me to make sure that my calculations for my tax levy purposes are perfect. And I can see a BA, that being something that they fret about that they previously never had to really consider when they were, talking about plans and such.
Yeah, and it's no different than, a teacher when the Teach NJ was passed years ago and there were new evaluation protocols and, teachers made the point that now I'm doing so much more work. Now it's more difficult to do an evaluation. It's going to be the same thing with a BA in light of that provision you're referring to. And it's kind of going to be a wait and see and learn and see approach.
Yeah, it's exciting.
Well, gentlemen, listen, we are running out of time, but as we close up, I want to throw you each one last question. And really, Geo, from a broker's perspective and Ari from an attorney's perspective, what do you think, particularly during this time frame, helping navigate the complexities of this bill is the best way to use Geo Brokers and Ari, the board attorney? And Geo, we could start with you.
Sure. So there's, and I love to talk about, misaligned incentives, and we talk about it constantly. There is something to consider here. So as you go into this SEHP, many of your brokers, many of the school board business administrator brokers are going to be kind of lost in translation, as the state plan doesn't pay a commission, right? So brokers are not going to be as excited about having a client move over there. And it's, I will say it plainly, they're just going to lose money. So they're not going to be as thrilled with you going and then actually helping out in the process. So what I do want to say, and I want to offer, that will offer, is there is a place in this marketplace currently for someone, a consultant or a broker, to be offering services to assist in the decision making and then to assist in the reporting. And then, and in between, some of the questions that some of the employees are going to have on whether they should pick a plan or how much it's going to cost. So there's an opportunity for brokers to help out with calculations, to help out with budgets, to help out with some of the enrollment process, as well as some of the reporting that's going to be going on. And I think it's going to be a race to providing a product or an offering that's reasonably priced, where you can then pick up clients that have went to the SEHPP and no longer have broker services that were included inside of the premium. I think some districts would be keen, and I think it would be smart to then have the conversation early with their broker and say, listen, I know that we're going to the SEHPP. You're going to be, losing out on, a large enough contract here. Let's talk about what it would cost to provide the services that we need while we go in there. And I think having that conversation up front allows you to look like you're, have the best interest of the district in mind at first, as opposed to saying, we're going to fight you making this move. We're going to tell you all the reasons why you shouldn't, only for, the end of it to come out that a lot of it was because you're going to be losing the money that was on this account.
Right.
Whereas you could have talked about this early on. So I think a smart broker is making, and mimicking those actions right now. Go ahead, Ari.
Yeah, and I agree with what Gio was saying. And one of the things I always like to do in negotiations, particularly now, is get the broker involved early and often, because you guys have more information than I have access to with regard to plan options, benefits, premium costs, et cetera, et cetera. I have found that that's been more difficult to do with districts in the state plan than districts in the private plan, and it's frustrating sometimes. Of course, if I'm sitting at the table negotiating a contract and I'm explaining something to the union with regard to benefits, they're going to be skeptical. There's no question about it. I represent the board. I don't represent them. So I think it's important, especially with this new bill, that the broker, to the extent the district could get them involved, and the board attorney work together with the VA, the administration, and the board to figure out how this bill, it's a lot of the information is fluid, and as we get more information, to figure out how this bill is going to impact the board, both short-term and long-term, so we can resolve some of the expiring contracts. Like I said, I have about 14 expiring contracts right now that are being worked on, and this is pretty much the single issue holding up the majority of them. The unknown of the financial impact of this bill, the unknown of the plan designs and the plan premium costs. So I think it's very important and beneficial to everyone involved, if the broker, the attorney, and like I said, the board and administration work together to figure these things out.
Great. Absolutely. And listen, guys, I couldn't agree more. This kind of reminds me a little bit of when the Affordable Care Act came into play. Districts leaned pretty heavily on their broker, but there were a lot of questions that were legal questions. So the districts who kind of worked in harmony between their broker and their board attorney on the same call, on the same room, whatever it may be, definitely benefited from that activity for sure. Because you get two slightly different perspectives from a broker. What's possible? What types of plan designs changes can we make? And what are the financials associated with each one of these decisions? And then, of course, of those, which ones are interpreted as a possibility from a legality standpoint or a CBA standpoint, right? So I think combining those conversations is key. Listen, gentlemen, thank you both so much for your time. Ari, really appreciate the conversation. We're always glad to have anyone from the Busch Law Group on here. You guys are a fantastic firm. And Geo, same to you. Always appreciate the conversations. So thank you both very much. I really appreciate your time.
All right,
Thank you.
Take it easy.